This is Book 1 of the Civil Code of the Philippines. Titles 3 on marriage, 4, legal separation, 5, rights and obligations between husband and wife, 6, property relations between husband and wife, 7, the family, 8, paternity and filiation, 9, support, were repealed by Executive Order No. 209, otherwise known as the Family Code of the Philippines. Title 10. Funerals. Article 305. The duty and the right to make arrangements for the funeral of a relative, shall be in accordance with the order established for support, under Article 294. In case of descendants of the same degree, or of brothers and sisters, the oldest shall be preferred. In case of ascendants, the paternal shall have a better right. Article 306. Every funeral, shall be in keeping with the social position of the deceased. Article 307. The funeral, shall be in accordance with the expressed wishes of the deceased. In the absence of such expression, his religious beliefs or affiliation, shall determine the funeral rites. In case of doubt, the form of the funeral, shall be decided upon by the person obliged to make arrangements for the same, after consulting the other members of the family. Article 308. No human remains shall be retained, interred, disposed of, or exhumed without the consent of the persons mentioned in Articles 294 and 305. Article 309. Any person who shows disrespect to the dead, or wrongfully interferes with a funeral, shall be liable to the family of the deceased for damages, material and moral. Article 310. The construction of a tombstone or mausoleum, shall be deemed a part of the funeral expenses, and shall be chargeable to the conjugal partnership property, if the deceased is one of the spouses. Title 11, Parental Authority, was repealed by Executive Order No. 209, otherwise known as the Family Code of the Philippines. This is Book 1, Title 12 of the Civil Code of the Philippines. Care and Education of Children. Article 356. Every child. 1. Is entitled to parental care. 2. Shall receive at least elementary education. 3. Shall be given moral and civic training by the parents or guardian. 4. Has a right to live in an atmosphere conducive to his physical, moral and intellectual development. Article 357. Every child shall 1. Obey and honor his parents or guardian. 2. Respect his grandparents, old relatives, and persons holding substitute parental authority. 3. Exert his utmost for his education and training. 4. Cooperate with the family, in all matters that make for the good of the same. Article 358. Every parent, and every person holding substitute parental authority, shall see to it that the rights of the child are respected, and his duties complied with, and shall particularly, by precept and example, imbue the child with high-mindedness, love of country, veneration for the national heroes, fidelity to democracy as a way of life, and attachment to the ideal of permanent world peace. Article 359. The government promotes the full growth of the faculties of every child. For this purpose, the government will establish, whenever possible, 1. Schools in every barrio, municipality and city, where optional religious instruction, shall be taught as part of the curriculum, at the option of the parent or guardian. 2. Poriculture and similar centers. 3. Councils for the protection of children, and 4. Juvenile courts. Article 360. The Council for the Protection of Children, shall look after the welfare of children in the municipality. It shall, among other functions. 1. Foster the education of every child in the municipality. 2. Encourage the cultivation of the duties of parents. 3. Protect and assist abandoned or mistreated children, and orphans. 4. Take steps to prevent juvenile delinquency. 5. Adopt measures for the health of children. 6. Promote the opening, and maintenance of playgrounds. 7. Coordinate the activities of organizations devoted to the welfare of children, and secure their cooperation. Article 361. Juvenile courts will be established, as far as practicable, in every chartered city, or large municipality. Article 362. Whenever a child is found delinquent by any court, the father, mother, or guardian, may in a proper case be judicially admonished. Article 363. In all questions on the care, custody, education and property of children, the latter's welfare shall be paramount. No mother shall be separated from her child under 7 years of age, unless the court finds compelling reasons for such measure. Title 13. Use of surnames. Article 364. Legitimate and legitimated children, shall principally use the surname of the father. Article 365. An adopted child, shall bear the surname of the adopter. Article 366. A natural child, acknowledged by both parents, shall principally use the surname of the father. If recognized by only one of the parents, a natural child shall employ the surname of the recognizing parent. Article 367. Natural children by legal fiction, shall principally employ the surname of the father. Article 368. Illegitimate children referred to in Article 287, shall bear the surname of the mother. Article 369. Children conceived before the decree annulling a voidable marriage, shall principally use the surname of the father. Article 370. A married woman may use 1. Her maiden first name and surname, and add her husband's surname, or 2. Her maiden first name and her husband's surname, or 3. Her husband's full name, but prefixing a word indicating that she is his wife, such as Mrs. Article 371. In case of annulment of marriage, and the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may resume her maiden name and surname. However, she may choose to continue employing her former husband's surname, unless 1. The court decrees otherwise, or 2. She or the former husband, is married again to another person. Article 372. When legal separation has been granted, the wife shall continue using her name and surname employed before the legal separation. Article 373. A widow may use the deceased husband's surname as though he were still living, in accordance with Article 370. Article 374. In case of identity of names and surnames, the younger person shall be obliged to use such additional name or surname as will avoid confusion. Article 375. In case of identity of names and surnames between ascendants and descendants, the word junior can be used only by a son. Grandsons and other direct male descendants shall either 1. Add a middle name, or the mother's surname, or 2. Add the Roman numerals 2, 3, and so on. Article 376. No person can change his name, or surname without judicial authority. Article 377. usurpation of a name and surname, may be the subject of an action for damages and other relief. Article 378. The unauthorized or unlawful use of another person's surname, gives a right of action to the latter. Article 379. The employment of pen names, or stage names is permitted, provided it is done in good faith, and there is no injury to third persons. Pen names and stage names cannot be usurped. Article 380. Except as provided in the preceding article, no person shall use different names and surnames. Title 14. Absence. Chapter 1. Provisional measures in case of absence. Article 381. When a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property, the judge, at the instance of an interested party, a relative, or a friend, may appoint a person to represent him in all that may be necessary. This same rule shall be observed, when under similar circumstances the power conferred by the absentee has expired. Article 382. The appointment referred to in the preceding article having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee, and shall specify the powers, obligations and remuneration of his representative, regulating them, according to the circumstances, by the rules concerning guardians. Article 383. In the appointment of a representative, the spouse present, shall be preferred when there is no legal separation. If the absentee left no spouse, or if the spouse present is a minor, any competent person may be appointed by the court. Chapter 2. Declaration of absence. Article 384. 2 years having elapsed without any news about the absentee, or since the receipt of the last news, and 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. Article 385. The following may ask for the declaration of absence. 1. The spouse present. 2. The heirs instituted in a will, who may present an authentic copy of the same. 3. The relatives who may succeed by the law of intestacy. 4. Those who may have over the property of the absentee, some right, subordinated to the condition of his death. Article 386. The judicial declaration of absence, shall not take effect until 6 months after its publication in a newspaper of general circulation. Chapter 3. Administration of the property of the absentee. Article 387. An administrator of the absentee's property, shall be appointed in accordance with Article 383. Article 388. The wife who is appointed as an administratrix of the husband's property, cannot alienate or encumber the husband's property, or that of the conjugal partnership, without judicial authority. Article 389. The administration shall cease in any of the following cases. 1. When the absentee appears personally, or by means of an agent. 2. When the death of the absentee is proved, and his testate or intestate heirs appear. 3. When a third person appears, showing by a proper document, that he has acquired the absentee's property by purchase or other title. In these cases, the administrator shall cease in the performance of his office, and the property shall be at the disposal of those who may have a right thereto. Chapter 4. Presumption of death. Article 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes, except for those of succession. The absentee shall not be presumed dead for the purpose of opening his succession, till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient, in order that his succession may be opened. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel, lost during a sea voyage, or an aeroplane which is missing, who has not been heard of for 4 years since the loss of the vessel or aeroplane. 2. A person in the armed forces, who has taken part in war, and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances, and his existence has not been known for 4 years. Article 392. If the absentee appears, or without appearing, his existence is proved, he shall recover his property in the condition in which it may be found, and the price of any property that may have been alienated or the property acquired therewith, but he cannot claim either fruits or rents. Chapter 5. Effect of absence upon the contingent rights of the absentee. Article 393. Whoever claims a right, pertaining to a person whose existence is not recognized, must prove that he was living at the time his existence was necessary, in order to acquire said right. Article 394. Without prejudice to the provision of the preceding article, upon the opening of a succession to which an absentee is called, his share shall accrue to his co-heirs, unless he has heirs, assigns, or a representative. They shall all, as the case may be, make an inventory of the property. Article 395. The provisions of the preceding article, are understood to be without prejudice to the action of petition for inheritance, or other rights which are vested in the absentee, his representatives or successors in interest. These rights, shall not be extinguished, save by lapse of time fixed for prescription. In the record that is made in the registry of the real estate which accrues to the co-heirs, the circumstance of its being subject to the provisions of this article shall be stated. Article 396. Those who may have entered upon the inheritance, shall appropriate the fruits received in good faith, so long as the absentee does not appear, or while his representatives or successors in interest do not bring the proper actions. Title 15, Emancipation and Age of Majority, was repealed by Executive Order No. 209, otherwise known as the Family Code of the Philippines. Title 16. Civil Register. Article 407. Acts, events and judicial decrees concerning the civil status of persons, shall be recorded in the Civil Register. Article 408. The following shall be entered in the Civil Register. 1. Births. 2. Marriages. 3. Deaths. 4. Legal separations. 5. Annulments of marriage. 6. Judgments declaring marriages void from the beginning. 7. Legitimations. 8. Adoptions. 9. Acknowledgements of natural children. 10. Naturalization. 11. Loss, or 12. Recovery of citizenship. 13. Civil interdiction. 14. Judicial determination of filiation. 15. Voluntary emancipation of a minor, and 16. Changes of name. Article 409. In cases of legal separation, adoption, naturalization and other judicial orders mentioned in the preceding article, it shall be the duty of the clerk of the court which issued the decree, to ascertain whether the same has been registered, and if this has not been done, to send a copy of said decree to the civil registry of the city or municipality where the court is functioning. Article 410. The books making up the civil register, and all documents relating thereto, shall be considered public documents, and shall be prima facie evidence of the facts therein contained. Article 411. Every civil registrar shall be civilly responsible for any unauthorized alteration made in any civil register, to any person suffering damage thereby. However, the civil registrar may exempt himself from such liability, if he proves that he has taken every reasonable precaution, to prevent the unlawful alteration. Article 412. No entry in a civil register shall be changed or corrected, without a judicial order. Article 413. All other matters pertaining to the registration of civil status, shall be governed by special laws.